topic so well, and even accounting for moderator hyperbole, Merrill is absolutely right that there is no group in the world better equipped to discuss this crucial topic: does the Supreme Court follow the people? There were a series of polls conducted recently by Quinnipiac University which found that up to 54% of the respondents believed that the Supreme Court should consider changing times and current realities in applying the principles of the Constitution. That contrasts with up to 44% who believe that the court should consider only the original understanding of the authors of the Constitution. And obviously, this debate between the living constitutionalists and the originalists has huge stakes. Earlier this week, in a case involving violent video games from California, we saw a fiery dissent from Justice Clarence Thomas, arguing that because the framers of the Constitution thought that parents should have total ability to control what their children read, including what he called, I love this part, vain books, profane ballads, filthy songs, or amorous romances. Therefore, California should be able to ban video games today. I think Justice Thomas was also struck that if the kids disobeyed the parents in the founding era, they could be beaten into submission. Now, Justice Breyer also dissented in this video games case, but on very different grounds. He found a series of empirical studies showing what he thought was a clear correlation between violent video games and violent action. He was appalled by the irony that you can restrict young children from buying topless magazines, but not gruesome and violent video games. And he said because of these empirical studies, the court should have deferred to the elected representatives in California and respected their democratic judgment. So this is the stakes of the debate that we're going to have today, and we're going to ask Justice Breyer about his opinion. Now, as it turns out, this vision that Justice Breyer and Justice O'Connor have defended more eloquently than any other justices on the court, namely that rather than inflexibly applying historical values, the court should work in partnership with the other branches of government to reflect the values of the people today, has a long history. In 1900, the fictional Mr. Dooley famously said, "The Supreme Court follows the election returns." That may be putting it a little more starkly than the justices believe, but in recent years there's been an explosion of scholarship arguing that regardless of what you think the court should do, this is precisely what it has done. Over the course of time, far from being a platonic guardian of inflexible values, the court has mirrored the views of the majority of the country, and on the rare occasions when the court has imposed values that are intensely contested by a majority of the country, it's provoked a backlash and often a judicial retreat. The most important of these books of a school that is now associated with the phrase popular constitutionalism was written by Dean Larry Kramer of Stanford, who coined the phrase. And in his path-breaking book, The People Themselves, Kramer argued that over time, values have been enforced by the people rather than exclusively by the court. He became convinced in the 1990s that the framers of the Constitution themselves expected it to be interpreted not just by judges, but by the people themselves through petitions, juries, voting, and civil disobedience. And he thinks it's a grave historical mistake to focus only on judges as interpreters of the Constitution. So this is the topic we're going to be discussing today. It couldn't be more rich and timely, and I'm going to begin by asking Dean Kramer to explain your thesis. Does the court follow the people, and should the court follow the people?
So I'm going to try and be quick here because I'm assuming that except for some small number of you who may have kids looking to get into Stanford, most of you have come to see the other panelists. And if you do, come see me afterwards. I took some notes because it's a relatively complicated idea that I want to get out on the table pretty quickly. And so the should folds into the what the court does. And it runs contrary to some things that I think in the last generation or so have become relatively commonplace to say, but that aren't really true either to American history or most of our past practice. So the first is the notion that the Constitution is a counter-majoritarian document. It's not. It was not meant to be a counter-majoritarian document. It's meant to be a majoritarian document. The very definition of Republican government as understood by the founding generation was majority rule. And the idea that any part of this government would not be subject to majority rule would have been contrary to the whole movement that had produced the revolution and the Constitution. At the same time, of course, what the first few years of experience had revealed was that simple majority rule posed some pretty significant risks, or in Madison's words in Federalist 10, ills incident to Republican government. And so they had to find a solution to that. And Madison writes about this, of course, in the Federalist Papers and talks about the need to find a Republican solution to the ills most incident to Republican government. And it's that first Republican that you need to focus on, because the solution itself needed to be consistent with the idea of majority rule. If you ever get a chance, go back and reread Federalists 10 and 51, which really lay out, I think, most clearly the theory that the founding generation, or at least the people who constructed the Constitution, had in mind for how that would be achieved. There were a couple of keys to it, though. One was to make the republic very large, with the idea that that would slow down the formation of majority factions, and so give opportunity for leadership within government to educate the public. And the other was to make the government very complex, have different levels and different branches within each level, again, for the same purpose, to slow things down, to provide numerous inlets for people with different views, to push their views, to give the different branches and levels of governments ways to check each other, all with the idea of forcing the debate back to the public, which ultimately had to be the decider on any question, but particularly questions of core constitutional values. So the key here, of course, is leadership. The understanding of democracy is not that government just reflects what an instant majority of the public thinks, but neither is it that government acts completely independent of what the majority of the public thinks. And the idea was to create a complex, ongoing conversation in which there's a degree of independence in the government, and each of the branches has a different degree of independence. Members of the House are different from members of the Senate, particularly as originally constructed when they were, of course, elected by state legislatures, different from the president, and different from the court. All have different degrees of independence, but all are meant to also have a degree of accountability so that they're not operating independent or fully independent of the public. Now, it's worth noting in passing that in the original construction of the Constitution, there was no significant role imagined for the court in this, particularly in constitutional enforcement. It would go too far to say that there was no role imagined. It would go too far to say that there was one view on this. All of this was new and just beginning to develop, so there was a small group of people who did envision a role for the court, although even they didn't envision a particularly significant one. And that's why there's no specific provision for judicial review in the Constitution. There were people who recognized that it might happen, but nobody thought it would be a very powerful check. They were focused on other sorts of checks. And then there were really most of the public had never actually even thought about the court as an enforcer for constitutional values. They thought it would happen the way it had traditionally happened all through colonial history and in the early republic, which was some combination of elections and petitions and pressure on the government, popular action, and so on. Nonetheless, a role for the court emerges quite early, and the idea of judicial review establishes itself within the first 10 years. Marbury v. Madison doesn't create judicial review. It really recognizes a practice that by that point has become relatively widespread. But it's a particular form of judicial review in which the court is one more voice in the ongoing public debate, neither more nor less significant than the other branches, and subordinate to the community at large. And so the court, when it renders decisions, is another voice offering views on the Constitution, but ultimately subject to what the people themselves, in the phrase of the 18th and early 19th century, what the public at large or the community at large believes its constitutional values should be, with the idea that this long, slow, complicated process has taken us to the point where this is probably as good as we can get. And it's worth, in thinking about that, to remember that there are never issues, the issues that actually come before the court or before the country. There are never issues that are easy or clear. The ones that become controversial are controversial precisely because there's disagreement. And it's not as though the whole elite agrees on what the right answer is, and it's just sort of the hoi polloi out there who don't get it. The divisions run all the way through. The court is typically divided. The public is typically divided. Intellectuals are typically divided. They are hard questions. And so the idea is to force the right kind of deliberation as much as you can, but with the idea that at the end of the day, it is the settled views of the public as reflected through the actions of political leaders that should determine what we do. Mostly this has not been a problem across American history, and so here we come to what the court does do, because the court is in a funny position. Unlike the other branches, it can't derive its authority from electoral politics. It can't claim that kind of mandate. And so the only authority that it has comes from its institutional authority and its ability to command the respect of the public. And commanding the respect of the public requires a certain amount of paying attention to what the public thinks. And so the court has, relatively speaking, played a deliberative role in which it has, for the most part, never or rarely veered very widely from strongly settled public opinion. And where it has, one or the other has yielded. Either the public has moved towards the court or the court has moved towards the public. And that's largely because with only institutional authority for support, the justices tend, as an institution, to be relatively miserly with respect to their, for lack of a better word, miserly with respect to their institutional authority. That is to say, they preserve it. And so when threats arise, when things seem to be getting a little too far in terms of the kind of pushback they're getting, the justices tend to temporize, and that's been the case from the Marshall Court forward.
Excellent. Thank you for setting up the topic so well. Now we get a chance to ask the experts. Justice Breyer, Dean Kramer has told you what the framers expected you to do and what you should do. Do you do it? Do you follow the people?
In thinking about what the dean said one way, I think, of course. Thinking about it another way, I think certainly not. And the truth does not lie between those two. Where I think it is, of course, is, and quite rightly so, people say quite often, well, you're just junior politicians. They don't say it. They think it. So in order to get the audience to say it, I say, that's what you're thinking. And they say, yeah, you're right. But they don't say it. They just think it. So I said, well, that's totally misleading, I think. I haven't seen that since there. And then I know what they're going to bring up. I say, no, I need an hour. I can convince you, I think, of anything. Politics, I used to work for a politician. I worked in the Senate. I worked for Senator Kennedy for a few years. And politics is why you didn't throw this young lady came into my office and she was going through all my law books and wrecking everything. Who are you? Well, she came in from I don't know where. But I suddenly thought, well, hey, she might be a constituent. I better be nice. Oh, that's politics. Because who is up and who is down? Who has the votes? Who doesn't? Are you Democrat? Are you Republican? No. That's really out. You mean ideology, that's what you mean. Are you an Adam Smith free enterpriser or a Maoist struggle session troublemaker? I mean, which is your true philosophy? And I say, if I catch myself doing that, I think it's wrong. Can't always not, but you try not to. But then there is a third thing. I mean, as I've said 5,000 times, absolutely true by now. I know it. I was born in San Francisco. I did go to Lowell High School. I have lived a certain period of time, and in any of our professions over time, you develop views in law, and if you're a judge particularly, there are views that you have about how law relates to the United States of America. What kind of country is it like? How does it work here? What are these rules? Are they rules? When are they? When aren't they? And of course, you can't jump out of your own skin, nor should you. Well, then why do we all come to the same conclusions? Well, I did grow up in San Francisco. I went to Stanford.
I know.
No.
Not the law school.
Now, my grandchildren are the one I'm interested in at the moment. But and I've had certain experiences, as we all have. Okay, fine. I was in Massachusetts. I lived there for many, many years, and I found people disagreed quite often. But I didn't know what disagreement was till I got appointed Supreme Court of the United States. Now I found people who really disagree. And I got annoyed for a while, think, why don't see things clearly? And I realized that isn't a bad thing. That is actually a good thing. The United States of America has 309 million people, and contrary to popular belief, 308 million are not lawyers. But they think different things. Now, presidents, over time, have appointments. A president who thinks that he's going to appoint a judge who will decide everything the way he wants is making a huge mistake. Teddy Roosevelt appointed Oliver Wendell Holmes. 3 months later, he's in dissent in the Northern Securities case. Roosevelt thought that was terrible, said I could carve a judge with more backbone out of a banana. He was annoyed. Well, he shouldn't have expected Holmes to follow him. But if they're thinking at a very abstract level of basic principles about how the country might work and how law affects those people in that country, they'll have better luck. Not 100%, but they will have better luck. So given the fact, as Jefferson said, the trouble with the court, he said, is that they never retire and they very rarely die. Therefore, we are there for a while, and there will be presidents. And they will appoint different people. And I've learned over time, finally, it took me some time to figure this out. People who say they want a conservative judge, whatever that might mean, or a liberal judge, whatever that might mean. The judges who are appointed are not people who want to do whatever the public wants, and they think the public's liberal or conservative. They are judges who truly believe that the law does call for the outlook or decisions in their decision. And that is why I think I can say I have not seen politics affect the decision of the court, although you hold yourself up to which way's the wind blowing? The one person who I think really did that, Roger Taney, Dred Scott. He thought by deciding Dred Scott, he would stop the Civil War. He started it, okay? That's how good politicians judges are. I mean, they're terrible politicians for the most part. But do you see, you shouldn't do it, you couldn't do it, and we don't do it. But over time, because of the change in the appointments process, you will get different judges. I say you should have a system where the judges are doing what they need. Because even beyond making good decisions, whatever that might be, I think the country will respect the court for doing what Hamilton in 78 said they should do. And I think what he says they should do is this document is there not just for the powerful, the document's there for the unpowerful. The document's there for the least popular person in the United States who has the same rights as the most. So this court will, from time to time, have to protect those very unpopular people, in which case the public will think they're out of their minds. All right? But that's the job. And as you can see what happens from Roger Taney, if you don't do it, I think eventually in history you'll be criticized a lot more than you will be by doing what the job is. So you see, I really agree with you because I think over time you're right. But if you're saying I'm going back there tomorrow and hold my finger up to the wind, I would say no, that's not the job. The job is to apply it. Now we have different views about that, but that's a different matter. And so I think people do, even when I disagree with them. They are trying to apply it, and they're not holding their finger up to the wind.
Wonderful. Well, Justice O'Connor, I had the great opportunity to interview you a few days ago. We had a wonderful conversation, and I said, after listening to you, how much the country lost when you retired from the Supreme Court.
I was there a long time.
You were.
So.
And you, among your many virtues, you had a great knack for moderation, for pragmatism, and for really expressing the views of the moderate majority of the country, sometimes even more effectively than the other branches of government. I want to be specific about this and ask you one question in particular. In 1992, when the court upheld Roe versus Wade, in an opinion that you joined, you said that early-term abortions had to be protected, but late-term choice could be restricted. That exactly coincided with the views of the majority of the country, who 2/3 of the country felt early-term choice had to be protected, and greater majorities thought the later-term choice could be restricted. Was that at all a factor in your decision? I can't imagine you read the polls, but were you aware of what the country thought at that time, and that influenced you?
Well, I can only say that most members of the Supreme Court do read newspapers. It's not forbidden. They do, generally speaking, know what's going on, and obviously members of the court have observed, at whatever distance it might be, the problems arising out of the controversy over abortion. And that's been with the nation for quite some years now. And the nation itself has never resolved that debate. There's no clear consensus out there, as far as I can tell, on the proper rules for regulating abortion. And so the members of the court are as aware of that as are you or any of us. And I don't think, as Justice Breyer said, I don't think members of the court read the election results and the latest polls to write an opinion. That isn't how the court was established. It isn't what it's supposed to do. It's supposed to find out whether the challenged law or public action is within the bounds of the Constitution. Well, there aren't a lot of hard and fast rules written in the Constitution. So the court has to look back at now over a great many years of written opinions by the court, because once they're issued, they become part of the law of our country. And when you decide a case, you have to look back at that too. So deciding an issue, the answer to the question, I don't know who wrote the question. It was not a very useful question, because the answer is clearly no to the question that's posed. But in a broad sense, the justices themselves are appointed by presidents. Every president, starting with George Washington, has tried to appoint people who thought like he did about key issues. I mean, George Washington wasn't going to go put someone on the court who had wildly different views from his own. Neither was Ronald Reagan, and neither is President Obama. They're going to look for people whom they believe have generally views that are at least somewhat consistent with their own views of the appointing president. And so over time, you're going to have presidents try, at least in their appointments, to find people when they appoint them who aren't going to be wildly off the chart from the president's own views of things. And as a result, you are apt to have effects on the Constitution in the decisions reached by the court. And I guess the example we all look to was back in the days when the court was overturning every action of Congress that came before them, and we had the justice who stepped down in the nick of time to save nine, Justice Roberts. And the court kind of changed its course and stopped overturning every single law that was passed by the Congress. And so it's, I think, logical to assume that justices, like presidents and like members of Congress, tend to have certain broad views about how the country should be responding to issues. And it isn't the job of a judge to reflect those views, but obviously every judge is affected in some remote way by their overall approach to things. Are you a person who thinks legislative bodies have power to enact laws, and by and large we should enforce those? It's the legislative judgment. So when the court has to look at them, we have to generally make an effort to enforce them. So I don't think they read the election returns and thereby make a decision. But to say they're unaware of broad views is unrealistic, too. So I think the answer is no. And now where do we go?
All right. Now, Dean Kramer, we have a little bit of a conflict between the court and the professoriate here. The two justices have said that, yes, although it's true in a broad sense that the court reflects views over time, each of them is shocked at the idea that any judge in a particular case would actually be swayed by popular opinion. So my question is it just a big coincidence? I mean, after all, you and others have assembled reams of data, polls and so forth, showing that in case after case, by and large, the coinciding of the people's views and the court's views is very precise. But they deny that this is intentional. So what are we to make of this?
Okay, so I have to preface this because I'm in a hard position here because I am, in fact, institutionally very beholden to the court in all sorts of ways.
I went to Stanford, too.
So as you see, very beholden.
It's not the court, it's the alumni
in certain
base.
ways. Well, and I've clerkships, and you have to promise you'll still take clerks after I speak.
We learned at Stanford.
So let me say a couple things. So one is, just in terms of what empirical literature shows, there's an empirical body of literature that dwarfs, what Justice Breyer cited on violence and video games with respect to the extent to which the court adheres closely to where the public is over time, and not over long times, like very precisely. I mean, abortion has been an interesting issue because, in fact, the public has moved significantly between, say, the time of Roe v. Wade and the time of Casey, and it moved in different directions, and the court tended to follow it, and it's really striking. Now, that said, so it's impossible to ignore those facts. I mean, they're out there, and they're pretty stark. That said, nobody thinks that the justices sit there self-consciously deciding that way. I mean, nobody does. And it would be too much to expect anybody who is in the role of a justice to not just to admit publicly if they did, but to actually go about the role that way. I don't think anybody does. On the other hand, think about your own process of decision-making with important decisions in your own life or anything like that. And it's a complicated process. So you know, I mean, I face this all the time as dean. I get the similar kind of accusations about why I've done what I've done. And of course, if I step back and think about it, I realize that because I'm always embedded in a lot of different pressures from a lot of different directions, the way I understand what I do is inevitably a product of that. So I don't think there's disagreement in the broad sense, except to the extent that I think it's a much more refined feedback mechanism than either of the justices have stated here. I think it's actually, there's a much closer correspondence, and it does occasionally veer way out. It veers way out when you do get justices, as we do occasionally historically, who are really strongly committed to an ideology, and so adhere to that even as the public continues to move. And then when the gap becomes too large, you get a very, very significant pushback, and that's what happened in the New Deal era. That's what happened. It was starting to happen, actually, at the end of the Warren Court, except there were 4 very short retirements, and so President Nixon got to change the membership of the court as a device for bringing it back around. It happened around the time of Dred Scott. It happened around the time of the Second Bank of the United States in the 1830s. It happened in the early Republic around the time of Marbury. So it happens, but rarely, and that's because most of the time the justices are embedded in the same society, come from it, and are inevitably to some extent aware. And for myself, as I say, I think that's a really good thing. I would be very, very troubled by a court that, you know, self-conscious said, you know, we really don't care what the community at large thinks. In fact, we only care what we think, that's not a part of the way we decide things, and I don't think that's the case for any of them or any of us or anybody who would be put on the court. One other point I just want to put out there, which is the hard cases are, I do disagree essentially with one way in which Justice Breyer just phrased something. It is never, in the hard cases, the ones that make us care about the Supreme Court, it is never the case that it's just a matter of figuring out what the law says, because the reason they're hard is because the law has run out for us. There really are open-ended, not that they're inconsistent with the law, but the lines of authority and the text and the history and all the sources, whichever ones you're drawing on, have put you in a position where there really are choices to be made that are not themselves being made by these materials. And it's really important to acknowledge that. To me, one of the most corrosive things that has happened in the confirmation process has been the inability to openly recognize that fact, so that when Justice Breyer points out that he was raised in San Francisco, went to Stanford, that these were influences that help shape who he is today, and so how he decides cases, that we have to run away from that in public debate is I think, a really serious problem when it comes to constituting the court going forward.
All right, Justice Breyer, the dean has accused you of false consciousness.
No more than the rest of us.
No. He says that, you know, you think you're doing one thing, but you're really doing another. But I guess I'm surprised to hear you resist so much the claim that judges shouldn't be sensitive to popular views. In your wonderful book, Making Democracy Work, you say the whole point of the court is to encourage democratic deliberation by deferring to the views of elected legislatures. I want to ask you how this plays out in the video games opinion. So it was important for you in the video games dissent that all of these statistical studies, which you and your law clerks found, which suggested a possible correlation between violent behavior and the violent games, supported the judgments of the elected legislatures, and that's why you said you should defer. If you hadn't seen those expert studies that convinced you of that, would you not have deferred, and would you have come out the other way?
If studies had come out the other way, maybe I would have. That isn't the same thing as being deciding through a popularity poll. I probably wasn't clear. I don't think law is mechanical. I think that there are many, many different features that go into it. But once you tend to work out, Sandra said this very, very well, absolutely true. My goodness, I've discovered that. Your first few years on the court, you make footprints. And it's very hard to escape those footprints you've made. And what the footprints are methods of working out in different areas very difficult kinds of cases. This term, almost 50% of the time were unanimous. That doesn't mean those cases were easy.
That's a higher percentage
than usual.
Yeah.
I think we took more technical cases.
Yeah.
We were 5-4 about 18%, 20% of the time. And I would say it's more the same usual suspects than it was when you were there. So that suggests some increased polarization. Then you say, well, why is that? Well, you'd have to look at putting aside vast numbers of cases. I think a good metaphor was learned hands when we interpret statutes. He was talking about, in some degree, it's true of the Constitution. He said a judge is like a musician in the sense that if you're going to play the surprise symphony, you cannot play it like a dirge. That's out of the picture, okay? Now, within the range of what's in the picture, there are degrees. And it's not just degrees free choice. It is degrees that you might get a little better or you might get a little worse, and that's what people are striving for. A very good example that impressed me at the time, because I think it's so typical of a really hard case. Arkansas, some of you may remember, not Arkansas, but the issue, said that no one can serve more than, I think it was 6 terms in Congress. And does Arkansas, under the Constitution, have the power to limit the number of terms of a member of Congress? Well, my goodness, that was difficult. Why? You look at the words. The words say that a qualification is a citizen of the United States, a resident of the state of which he is elected, and over 25 years old. And it doesn't say whether that's all. If that's all, then they can't. If you could add others, they can. So, I don't know, look at the words. Read them 50 times. It's not going to help too much. Well, let's use common sense here. Couldn't you keep a lunatic out? You say, all right. But you cannot. Oh, of course. Well, if you could keep a lunatic out, well, what about insisting you own property? Oh, can't do that one. Well, let's look at what they did at the time. There was a state that did have a property qualification. I think it was Virginia. And the others didn't. So was that a fluke or does it show the trend? Well, let's look at what the founders said. The founders, fabulous, because you have Jefferson and Story close to being the founder. He said, of course they can add these things. You have Madison and Hamilton saying, no, they can't. So and the precedent went both ways. Absolutely. I've never seen, we sat there absolutely amazed. In my own opinion, what it sort of came down to, and you say, well, is this I don't know what you call this. I think some judges instinctively look at the 10th Amendment and they say that reserves to the states the powers that are not delegated in the Constitution. It reserves the powers to the states. And that 10th Amendment is very important. And the more important you make it, that's degree. It doesn't tell you somewhere. The more you think Arkansas should be able to do what it wants. But then there are others who will focus on Article 1, the legislature, and its power to control its own qualifications, and they will think, my God, that has to be widespread, because otherwise the staffs will get in control or all kinds of terrible things, and they'll lose their power in the Senate and the senators who are elected or the representatives, and it will move us away from that democratic system. That's all in the Constitution, too. And the more you put weight on that, the more you think they should not be able to do it. And the case, if you'd heard the oral argument, if there ever one would be broadcast, that was it. People were really trying to figure this one out. And it ended up 5-4. And it was 5, they couldn't do it. But you read the opinions, I think the correct response to the opinions, gee, I'm not sure, that's a tough case. Now, never in that calculus, which I've tried to give you a little at some length, because I want you to just introduce you to what some of these are like, never in that calculus are you thinking, is it popular to have term limits or isn't it?
Just one quick word. Just to clarify something, no one is saying, including me, no one is saying, any more than the other branches of government, what do you think politics is? That's actually what I resist. The idea that whatever the public thinks is therefore politics, it's blowing with the wind, that is not the idea at all. But the idea that what everyone else out there thinks is irrelevant, to be resisted, that it's a virtue to go against it, that also strikes me as deeply, deeply troublesome. Ask yourselves, what is the difference between that and a monarchy? except that it's limited just to some portion of the government, although it's that portion that we tend to want to identify as the most important and central one to us. It's our core values. So we're going to say we're going to have a democracy except for the things that are really important. For those, we're going to give them to people who we don't elect and who get to be there for life, much like a king, and let them do what they want. That would be a problem. Now, I don't think that's what is going on. I hope that's not what's going on. I'm sure that's not what's going on. But the extent and the way in which and the notion and the responsibility that a judge might have to be paying attention to where the society is, meaning not just what's popular out there for the moment, but what is this, where there are settled views, what are the trends, what are the views of the public, that has to be a part of the job. And I would be scared.
It certainly is a part of the job to the extent that a judge wants to understand that. And if you take a position under the Constitution that is against the majority view, you have to be able to explain it well enough that maybe you can persuade some of that majority to agree with you for the reasons expressed. That's the effect of it, not that it controls the vote, but it makes you very conscious of what you have to explain to the public when you write an opinion.
Yeah, and it's ongoing.
Yes.
Example that you brought up. Why look at all those studies? Because over a long period of time, in many First Amendment cases, not just this one, I've tended more in the direction to say, let's look to see what the genuine harm is to First Amendment interest, to expression. Let's look to see what the justification is that the state wants to restrict expression. And let's look to see if there are alternative systems. And often you find something in all those categories, and there's not much of an alternative to do a little balancing. But in this instance, I looked out and said the restriction on speech is that a child, 16 or 13 or 15, under the age of 17, cannot buy an X-rated or sort of, I will not describe them to you, video games without their parents' permission. But if the parents want them to have it, they can go get it. So I say that's something, but not much of a restriction. Then I look at the rationale for it, and I find that 130 studies or whatever they are, and I say that's not such a bad rationale. And I look to see if there are alternatives. I can't find one. Okay, you see the model there? That does not have to do with whether video games are popular or not. It has to do with trying to work out how the law is in this area. And it's not definite, and judgment is always entering, and you're never certain because there are very good arguments on both sides. But that's not a system which is simply looking to the public.
So the answer's no.
Yeah, the answer's
right. I agree.
Actually, I don't think the answer is no. I think the answer that you guys gave is actually partly, and fortunately so, partly. That's actually what, and I would have to agree with that, I say.
Justice O'Connor, how would you have approached the video games case? You both agreed on so many things, but would you have thought the First Amendment banned the sale of the violent video games or not? And why?
Well, one wouldn't just on the surface of things think that the court reached the decision you'd expect. Now, I don't, as a former member of the court, I'm not going to sit here and say, oh my God, they made it, But you don't read it and think that's what is required. The First Amendment, that is.
So you would have been with your former colleague. That's
you draw your own conclusions.
I just did. All right, Larry, once again, the professoriate has to return to its statistics. So the affirmative action cases remarkably track public opinion. When Justice O'Connor wrote her path-breaking opinions suggesting that some forms of affirmative action were permitted, but hard quotas had to be rejected, the public was in the exact same place, supporting affirmative action but opposing racial preferences. About a few years later, in the 2007 Parents Involved case, the country's more conservative, questioning affirmative action, and the court restricts it more. Justice Breyer wrote a 70-page dissent. He was so exercised, and this is the way he expresses his distress. He writes these great dissents.
I punish people by making them read it.
Making them read it.
So my question is, Were they obviously not following the polls, but were they unconsciously influenced by it? Or was it the fact that Justice O'Connor had been replaced by a justice who took a much less pragmatic approach than she does? He had a strong ideology. He's not as interested in public opinion. And it just is these 5-4 splits are the result of that.
Well, again, there's no easy answer. I mean, I come back to, we all need to reflect on our own processes of decision-making and whatever it is, and they are complicated, and many things enter into it, and they have different effects, and it's not false consciousness, but there are things with different degrees of consciousness in driving our decisions. So that's part of it. Part of it clearly is the changes in the appointments process. I've actually taken the position publicly. I think it's downright immoral for a president to make appointments to the court with the idea that what I'm really going to try and do is get justices on there who agree with my ideology, who are really young, so I can extend it well beyond my term in office.
Well, that's what they've done ever since George Washington.
Well, no. Actually, not since Washington. It's really a product of the last 30 or 40 years that it's been, let's find people who are young and who've said nothing so we can slip them through the confirmation process and will be on there for a really long time, and are pretty open about that these days, which is somewhat, so that's an effect as well. But there has, nonetheless, across American history, even without formal term limits, been a relatively steady turnover on the court. The average tenure of the justices actually has been around 9 years. That's changed, and it's getting longer now, and that's why we're seeing more tensions and will as time goes on. So what happens there, though, when you have the regular turnover then, because presidents still do tend to try and put people on who roughly share their ideology, is, you get some concurrence there. I think we're in a period where it's quite possible, depending on the direction the country takes, that you could have one of those rare periodic large divergences where you have justices who are not pragmatic, who are very ideological in their decision-making, who don't care what the rest of the community thinks, and that's when you get trouble, right? That's when it happens, because politics inevitably will only accept so much from the court, and that's what happened around the time of the New Deal, and it has happened periodically. Mm-hmm. And as I say, as long as there's a rough concurrence and the long-term kind of trend that Justice Breyer talks about, we don't get flashpoint conflicts, but when you get big divergences, they inevitably come about.
Very good. Ladies and gentlemen, I think it is time for your questions, and there will be mics roaming around. And
you have a hand in the middle.
Yes, right in the middle. Yes, ma'am. There's a mic just coming over to you now.
My name's Jane, and I didn't go to Stanford. Is it okay? It's okay to ask a question?
It's fine. You're among friends, nevertheless.
How would you respond to those that really believe that Bush versus Gore was a political decision of the court?
That what?
Bush v. Gore was political.
Oh, Bush v. Gore.
That's what Justice Breyer said he needed an hour to explain.
We were on different sides on that question.
Well, I'd say it was my point of view, all right, because that's... I said at a Stanford audience, actually, I get that question, and I said, I was in dissent. I thought it was completely wrong. At Stanford audience, had big applause. So I said, moreover, before I think my side was the more popular side by a few hundred thousand. But two things. One, before I could make that decision, I had to imagine in my mind, would I make the same decision? If everything were the same, but the names reversed. Okay? And unless I can be comfortable that I would do that, I can't. And I had to do it. I went through, because I'm far imaginative, and I go, well, what happens if it me, blah, 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 blah. All right. Anyway, I went through a process and came to that conclusion. And then I foolishly said, of course, I could kid myself, and people do kid themselves, but you try not to. And I am sure that all my colleagues did the same. Is that? And that is that's what I think people haven't taken that into account when they say, oh, it's just politics. The other thing, which maybe I'll discuss tomorrow, but one very good I heard Harry Reid say about that decision, a great thing, was people did follow it, even if they might think it was wrong. And that I think, speaks well for the court. And I'll tell you.
We are lucky that even in very divisive cases, the country has followed the decision that's been handed down. We haven't gone to war over them. And that's a great blessing. It shows that the system is more or less working. And in Bush-Gore, it was a federal election of a president. And they're carried out at the state level. And in this case, it was Florida. And it boiled down to the votes in 4 counties. And it turned out that Florida did not have uniform policies to instruct the little volunteers who were counting the votes on how they should count these ballots out of machines they had never used before for voting, which left hanging chads. Remember that term? And some were hanging by 3 corners and some by 1 and so forth. And no instructions were given to the vote counters how to deal with hanging chads, for instance. So what kind of a result were you getting? Because it was very close. And we took the first case and unanimously sent it back to Florida, and the court did not respond. It never has. And they never instructed the voters. So back came the second case. And there we were divided 5-4. But it wasn't the end of the world. When it went back in favor of Bush, all of the ballots were saved. All of them for the 4 counties. And the press had access to them, and they had recounts of the votes in the 4 counties by the press. It did not change the outcome at all. So forget it, okay? It's over.
Look, if people don't, I was thinking of this because it is an example, what I think a basic job, and I'm looking for a disagreement because at some level we don't disagree too much and we're looking for disagreements. But this is one where maybe we do. That I think that what this shows and what other cases show is one of the main jobs of the court, not always emphasized. But I find that in Hamilton 78. I find it in Federalist 78. That's a serious matter, making a decision where you're making it in favor of someone who's very, very unpopular. E.g., we had 4 cases involving Guantanamo, including what you wrote, I think, was bin Laden's driver. Bin Laden's chauffeur was not the most popular man in America. He was bringing a case against the most powerful President Bush. In each of those cases, it was a similarly unpopular person. And in each of those cases, the court decided in favor of the unpopular person. Now, I'm not saying that's the only thing the court does, but I'm saying that's one of the things. And that takes a very, very long time. And if the public will go for that, then we're following the public. And it has to go for it, because the secret to this court, it seems to me, is a long period of time over which people have gradually become educated to the point where they will accept an institution that is not a monarchy, not elected, not democratic, making decisions that will often be unpopular and may be wrong. Because since we're humans, after all, we do decide things that are wrong. And how can you get the popular support for that? So I would turn his question on its head and say, it isn't that you are reflecting every jot and tittle, certainly, of public opinion. The important job is why she's out there every day with iCivics and trying to get civics into the classroom, is how you maintain the acceptance in the next generation or 2 of a system that does have these 9 people there, and sometimes, but certainly not always, they may do the right thing.
Larry, you shrugged. You think the court was being less heroic in those Guantanamo cases than Justice Breyer suggested?
I think we need to define what the issue was from the public perspective. So the question wasn't whether the individual people were popular or not. The question was, where did the public stand on the same questions with respect to executive power and the way in which we should treat even very unpopular people? And actually, the court took the popular line. It was the Bush policies that were very unpopular through there. And the court was on, I think, the right side of public opinion for what it's worth. This is actually all well documented, out there. So
I hope my studies were better than this one, because I think if you put to people the question, are you in favor of protecting the country from national terror, from terrorists by locking them up in Guantanamo, or are you in favor of letting the judge let them out?
Sure,
I have an idea if you put it that way.
I have no question if you put it that way.
Yeah.
On the other hand, if you put the question to the public, are you in favor of the United States betraying all its core values and locking people up with no process, no opportunity to talk to a lawyer, no opportunity to have the evidence against them checked or tested, you get the same answer as well.
Protection of national security versus protection of traditional civil rights. What's the answer? I don't know the answer.
I don't think there is an answer.
What does the public say? What is the
public? There's not an answer to that.
There is a poll, actually. The public was asked, what do you think of the Patriot Act? And 50% thought it struck the right balance between liberty and security. 20% thought it didn't go far enough. And only 20% thought that it went too far.
That's what we held on
the people who thought it went too far, most of them are in this room, actually. But it's a coalition of civil libertarian liberals, libertarian conservatives, and the Aspen Institute, essentially. That is a minority of the country.
Now I feel like I actually am fighting a little uphill battle, because what I do find, and I will just say this frankly, is I think most liberals also hold most of the country in relative contempt for their intelligence and ability to make decisions, and I don't. I'm actually teaching a course this coming year with Josh Cohn, who's a political philosopher, on democracy and constitution, in which we're really trying to recapture, this is a Lincoln's line, about the long, slow wisdom of the public. And that's really what we're talking about here. I reject polls pretty much actually top to bottom, because they are entirely a product of how you frame them. And asking somebody, do they favor the Patriot Act or not, in that context, with no further information, with no sense of the details and the particular details that were at issue in these cases, just is useless. On the other hand, as I say, the polls that I looked at actually put the facts out there and the issues at stake, and there was actually general opposition to what the Bush administration was doing. For what it's worth, I don't think that's what drove the court. I just don't think those are good examples of the court heroically standing up to the public. But I don't think that's the right way to frame it either. What I've been trying to say all along is, Justice O'Connor said also, and I think Justice Breyer also, it's a conversation that the court is engaged in with the public. And what I'm concerned about is not justices like these, but justices who, in fact, do not regard a conversation with the public as important or relevant. Because there will be a point when you've got sufficiently strongly ideological people up there who do not regard that as their responsibility, that you are going to get trouble, right? And that's what I worry about. So I didn't ask the question, by the way. It was his question. But to the extent that the question is being asked, I'm more interested in the should question, which is absolutely the justices should and must be aware of what the larger community around them thinks. And if they think that community is wrong, they should try and explain otherwise. But they have to be listening to the feedback as well. And when the point comes that there's been a long-term engaged public debate, I don't want a court that says, well, we're right and you're wrong, and that's all there is to it. You have to obey us, because that's not going to produce a healthy democratic republic.
Justice O'Connor, the Abu Ghraib pictures came out, I think, several days before the oral argument in the Osama's driver case. Were you aware of those, and did that influence you at all?
I don't remember that I was aware, and that isn't the basis for the court's decision. Now, we have time for about one more question out there.
A few more than one.
Some hands
We've got
up.
a lot of hands, and we're going to take them all. Yes, sir, right here in the front.
They're bringing a mic.
Given the comment that presidents are appointing younger judges, and that longevity obviously is much greater today than was when the Constitution was written, is it still in the public interest to have lifetime judges?
What's the question?
Is it still in the public interest to have lifetime tenure for judges?
Well, you can always have the Constitution changed. Do you think you could get support to change it? It's tough. Good luck.
Yeah. No, you have to have a long term. You have to have a long term. If somebody says 18 years as opposed to life, fine. I mean, you want a long term because you don't want people thinking about the next job.
I'm okay with 9 years. It's worth noting that almost all of the modern constitutions that have been written post-World War II have courts with judges who have limited terms that are staggered with exactly the idea of producing a regular turnover.
Yes, most countries, and there have been many, that have formed or adopted constitutions in the last 25 to 30 years have set term limits for their highest court judges. The framers in our Constitution didn't. And the only way to change it is by an amendment to the Constitution. And maybe there'll be public support for that someday. I don't know. I haven't seen evidence of it so far. So, and I don't know, we are living longer and therefore serving longer. So it is a legitimate question to ask what our public policy should be. But as of now, there is no limit.
More questions? Yes, sir, over there, by the side. Sorry, I'm making you jog across the room as part of the Zika Manual Fitness Program at the Aspen Institute.
Hi. So how did the original intent advocates on the court now rationalize recent First Amendment decisions regarding the free speech right to marketers selling prescriber data and not leveling the playing field in political elections? How does that jibe with original intent? And since it's so hard for me to understand how it does, how can we understand it as something other than a political decision?
Great question. Justice Breyer, you were in dissent in that pharmaceutical privacy case, and you certainly were part of a fiery dissent in the Citizens United case. How can that be reconciled with original understanding?
I leave it to other people to discuss the contradictions of their own opinions. I have enough trouble explaining the contradictions in my own.
None of the language of the Constitution had been tested at the time it was adopted. It's framed in broad terms throughout. And they did a fantastic job when it comes down to it. That doesn't mean there can't be very tough issues today. And that's the job of the court, to try to explain when the court decides some of these cases, to explain to all of us why the majority reached the outcome it did. That's the big challenge, because it isn't always clear from the language of the Constitution. And that's the job of the court. That's why it matters how we get good people on the courts of our land. And we care about it for that very reason. But I just think you have to hope that those who are serving as the nation's judges and those on our highest court can think through these issues and explain them well enough that all of us out here understand the reasoning.
Larry, you can be a little less judicious. Do you agree that the framers of the Constitution would have protected corporations as persons?
I actually think the framers of the Constitution, they would be confused. There's no concept of corporation in the modern sense.
They hadn't thought about it.
Right. Sorry.
Yeah.
No, what I do think is this. I think people, we all have commitments, lots of them, and they're kind of hierarchically ordered. There are things we care about more and things we care about less. And this is true for judges as well. So they have a hierarchy of commitments, some of which are jurisprudential, some of which are substantive. And for anybody, for judges no less than anybody else, when a higher commitment comes in conflict with a lower one, the higher one wins. And how important a jurisprudence is to a justice or a judge just depends. God bless Justice Brennan, who I clerked for. He had a jurisprudence. It was a relatively weak commitment for him. He had many more substantive commitments that he cared about. And so there was a great deal of inconsistency jurisprudentially in his opinions, but it's understandable in terms of the man, and I don't think necessarily inappropriate for a judge. Other judges, so for any, Justice Scalia is an originalist to a point. He cares more, obviously, about the better example than First Amendment for most of them is race issues. So it is completely impossible to be an originalist and take the position the conservatives have taken on affirmative action. Completely impossible. And you'll notice in the opinions they don't even try. They don't do the historical argument there because they have a stronger commitment to a particular notion of equality that is colorblind or whatever, and that's what trumps in those cases. So that's just going to be the case with any decision maker and anybody deciding.
But it is not. Remember that you see, you're getting one side of it when you read my dissent or John Stevens, which I agreed with. There is a serious argument, which I don't agree with, and I don't want to convince you of it. But there is a serious argument that campaign finance restrictions are contrary to the First Amendment. And the argument in outline form is simply that money is not speech, but you try speaking in today's political world without money. You can't. And therefore, when someone wants to give money to a candidate, that will enable the giver and the receiver to get across a political message which is important under First Amendment principles because the country has to run on a conversation of different views. And when you try to limit that for however good a reason, you want to equal the playing field, you get into what learned hands said. Do not go down that road, the road of trying to limit some speech to get more from others. And he said the reason for that was because he said, if you do that, you will discover yourself enmeshed in a host of restrictions that no one will understand, and you will find that many of those restrictions could be written by people who want to write themselves into office. So don't try. Now, that is a theme that underlies many of the opinions with which I have disagreed. And what you see is the working out of that theme in a whole host of areas by people who believe it strongly. So I'm not going to bore you with why I think that's a bad idea, but there are arguments I want to show you on both sides, both people, both groups, honestly committed to different perspectives on important issues which are not cut and dried. This is right and this is wrong.
Yes, ma'am, right toward the front here. Right. You've got the mic there. Go ahead.
I'm Stefan Edlis, and I'm not going to ask a softball question. It has to do with trust in the judicial system. Judges can't do everything. They still are governed by a code of ethics and code of conduct. Let's consider a theoretical situation where a judge is married to someone who has an interest in a specific advocacy and makes a lot of money. How does a judge get in a position where he has his own view on whether he should recuse himself or not?
Well, as you know, there's no code in the Constitution telling judges at any level, federal judges at any level, when they should recuse themselves. And it's been left to the good judgment of the judges themselves. In some cases, courts have adopted general guidelines to be used by the judges. I think we have some general guidelines for the federal court judges in what to use to decide whether you should be recused or not. And there isn't such a code at the Supreme Court level, so what most of the justices have done in recent years, I don't know what they did in earlier years, was if there's a real question, they discuss it with their colleagues and get advice from their colleagues on what to do. That's not a bad way to go, I think, in terms of deciding it. But there's no written code, and they've generally followed the one that applies to all the lower court federal judges.
In the last few years, this has come up more, and I bet most. In my office, I have 7 volumes. The 7 volumes are the codes of ethics that comply, that all federal judges are supposed to comply with. Now, technically, I'm not bound by it, but I have yet to find a situation where any judge on our court, in any difficult situation, would not try to comply with the same code of ethics as everybody else. I know I do. I know Tony Kennedy does. I know anyone I've discussed it does. So this is a false issue in my mind. Now, as far as what your wife does or your husband, I myself have tried to stick to a certain principle, and I feel fairly strongly about it, that a wife or husband is an independent person, and they make up their own minds what their career is going to be. And you work that out together, but if person X, the wife, decides she wants this career, that's just fine with me. And if there is going to be something, for example, in the disclosure form, every year, I have to disclose every penny that I earn or have as an asset, that my wife earns that has as an asset, that any minor children earn or have as an asset. And it costs quite a lot of money to pay accountants to do all that perfectly, because you know there's one thing wrong, that there's going to be a headline. And therefore, some of these decisions are pretty tough, but you work them out the way judges work them out. The Supreme Court's different in one respect. In every other court, if I decide, and I have a close matter, to recuse myself, hey, that's the easy decision. That's one fewer case I have to decide. And besides, they'll bring in somebody else to decide it. If I recuse myself on the Supreme Court, there is no one else. And that could switch the result. So before, in a really tough case, I have people I telephone who are experts in ethics, and they'll let me know what they think, and they won't necessarily, they don't have to follow it, but I'm certainly guided. So ethical questions do come up sometimes. I think they have to go in very carefully, and I think the fact that my wife, who happens to be a clinical psychologist at Dana-Farber, and when I get cases involving psychology, I sit in those cases, okay? And I can't tell you how many times Sandra and I have been asked to go to conferences where they'll be for one of the Navajo reservation, a lot of them. And they don't have the money, and somebody comes in, how are you going to pay for that? We say, go to a foundation. So they go to a foundation, get the money. Okay. I don't see anything wrong with that, and I would continue to do it. And so there are a lot of things, I'm saying, in this world that are actually a lot tougher when you look at them through the microscope, case by case, and understand the duty to sit, as well as the duty to recuse, and the independence of two members of a family who are married. I say you bring all that thing in, and the cases you're thinking of might not be quite so easy as you think they are.
Ladies and gentlemen, at the Aspen Institute, as at the Supreme Court, it's important to end on time. So I just want to note, in conclusion, that you have seen a vigorous disagreement between our jurists and our scholar at the suggestion that justices actually follow public opinion in particular cases, but you've seen broad agreement that over time the court does reflect the broad currents of public opinion, and most of all you've seen the commitment that both of these two justices have to engaging in a dialogue with Congress, with the people of the country, rather than imposing constitutional values from on high, and for that reason we are very lucky to have them on the Supreme Court. Please join me in thanking them.